the other common one is subject to building and pest inspection. And of course, if you're going to get ready for an auction, you do that prior, or maybe the owner has done one and it's an acceptable one to you. You might do another one, whatever the case may be. But a contract that's subject to a building and pest inspection allows the purchaser to do that inspection after the binding point of the contract, so when it's under your control, and you can terminate in certain circumstances. So certainly not if there's cupboards that don't close properly just because the handle's broken, or you don't like the look of the flooring after you've purchased it. It's generally based on a structural element of the building, or some sort of cost that is really unexpected, and reasonably significant. Now, one of the things about those, yeah.
I was going to ask you, because obviously it's not something we have to worry about very much in New South Wales, but for you up in Brizzy, do you find there's ever an argument as to what constitutes a satisfactory building inspection?
Yeah, there can be. Yeah. So the condition as it's written into the REIQ contract compels the buyer to provide evidence to the seller if they are going to terminate under that condition by providing the written report. And then the seller has the opportunity to review that and say, well, hang on, I don't agree that this is unreasonable. It is very rare that a seller could stop a termination under a building and pest clause unless there really literally wasn't anything in there. But they could certainly argue that it's unreasonable. There is a reference to the buyer being reasonable in the assessment.
I love that legal definition of reasonable. What a reasonable person would expect or do. What is reasonable?
One of the opportunities that buyers have, if there are issues found in a building and pest inspection, and again, we go through this in great detail in the course, is you can either accept it how it is, you can quantify how much it would cost to remedy the issues that have been found, and let's say, for example, that comes up to $20,000. We had a plumbing inspection on a property. There was $30,000 of remedial work needed to be done. So we renegotiated with the owner to adjust the price to compensate for that. They had no idea those issues were down there, and
it's often the case
themselves.
Yeah. I remember,
but they don't have to accept that. I just want to finish that point off.
Yeah, okay.
The seller does not have to accept any renegotiation, and then it's up to the buyer to then say, all right, well, I don't want to pay this $30,000. I'm just going to walk away from this property and get my deposit back and move on to the next one. So whilst you might be able to quantify and reveal information about the structural elements and issues of a property, you can't compel the owner to adjust the price to represent how much it will cost you to fix that, or compel them to actually fix it themselves. So you still have the control of being able to say, no, I'll take it as it is, or no, it's too much, I'm going to walk away and go and find another one.